decision processes in the Supreme Court. It resulted in his book, Deciding to Decide, Agenda Setting in the United States Supreme Court, which you might imagine he assigned to his Bunnell students. He will be speaking on the court as an institution and providing us expertise from a political scientist perspective. Finally, Katie Barlow recently joined SCOTUS blog as the media editor after practicing white-collar criminal defense at an international law firm for 6 years. She co-founded Circuit Breaker, a news website covering the daily and breaking news out of the U.S. Court of Appeals for the District of Columbia Circuit. She also hosts a national political podcast called Words Matter. She provides legal analysis for MSNBC, Al Jazeera, and WNYC. She earned her early career stripes as a tote and turn working for Nina Totenberg covering the Supreme Court. She will provide insight into the Senate procedure surrounding this nomination process. The speakers will make opening remarks followed by questions. Ms. Barlow will go first, followed by Professor Vladeck, and ending with Professor Perry. So with that, I'm going to go ahead and turn it over to you, Katie.
Thank you, and right on time. My poodle joins the background. Hope that won't be too distracting, but I'm the only one here, so that'll keep her the most quiet. Thank you so much for having me. It's a pleasure to be here and to be back down south, virtually at least. In case you missed the talk at the top, I'm from Georgia, born and raised, went to the University of Georgia for undergrad. So among so many Texas football fans, I must say go Dogs in the middle of the season. As Seth mentioned, I'm going to talk a little bit about the procedure and the procedural hoops that the senators are going to need to get through to get from nomination to confirmation, provide some historical context about what has happened in the past and how this one's going to be different. So just at the top, kind of giving an overview and looking at Amy Coney Barrett's nomination to confirmation phase, there are a couple of things that are going to be exactly the same as her predecessors in nomination. There's a lot of talk right now about everything that's going to be different, and I'll get to that, and I'm sure we'll delve into it. But a couple of things we already know are going to be the same. Chairman of the Senate Judiciary Committee, Lindsey Graham, has scheduled a Judiciary Committee hearing. So we know that the Senate will rely on that vetting process through the Judiciary Committee and a vote out of Judiciary Committee to get to the full Senate floor. There's nothing in the Constitution that requires the Senate Judiciary Committee to be involved, so that could be bypassed entirely, but we know that, at least for now, that's happening. Her hearing is scheduled for next week, Monday through Thursday. That's also standard operating procedure for a confirmation hearing. The first day, we'll hear opening statements from the senators, probably from the nominee herself, and then they'll get into questioning back and forth, and we can get in the details of what that looks like later on. But suffice to say, the process itself will look largely similar to what we've seen from the other justices that currently sit on the court and those that came before them. Now, let's talk about what's different. So there are two imposing factors here that we all know about that are going to change the game. We're racing towards election day. We're 26 days out. And we also have the COVID-19 pandemic. And both of those are factoring into the political calculus on both sides of the aisle, dealing with her confirmation process. So talking about the election, the Republicans are on a truncated timeline. This process from nomination to confirmation usually takes 10 to 12 weeks. If you took the average of the 8 justices on the current court, it averages out to about 78 days, a little more than 11 weeks. The Republicans now are doing this in 4 weeks. So that means there's very little room for political error. Everything has to be run on a tight ship. And so far, everything is staying on schedule despite the COVID-19 pandemic that's happening. During this timeline, all of the similar things are happening. They're just happening in shortened form. So there's a background investigation that occurs where the Senate Judiciary Committee reviews and asks the nominee for all of her materials, everything she's ever written, beyond just her opinions, everything she's ever said in public, everything she's ever signed on to. She turns that over to the committee in a questionnaire form. I think hers clocked in at around 65 pages, which is probably about right. And it's important to note that her predecessors and fellow Trump appointees, Gorsuch and Kavanaugh, had over 10 years on their respective circuit court benches, lots of opinions to get through and lots to disclose in their questionnaires. And that took a great deal of time. In fact, it usually takes about 6 weeks. She was confirmed to the Seventh Circuit in 2017. So for the most part, she had all of her stuff together. She just needed to update between 2017 and now. I will say she's made a lot of public speeches and commentary in the last 3 years, so it did take some supplementing, but she only had to really supplement that 3 years worth of information for the Senate. So that's the election factor, truncated timeline, everything's happening quickly. Now, COVID is also impacting everything, and that story is evolving daily. Never before in a confirmation process has it been a potential danger to the senators to be physically present with each other. And that's a problem because the Senate rules require the senators to be physically present with each other to confirm this nominee. There are potential exceptions to that, and we can get into the details, but for right now, those are the contours of the situation that we're in. We know that 3 Republican senators have tested positive: Thom Tillis from North Carolina, Mike Lee from Utah, and Ron Johnson from Wisconsin. That takes away Senator McConnell's quorum that he needs of 51 senators for the Senate to do business. And I suspect that's why McConnell agreed with Democrats to be out of session until the 19th, although, as we know, Judiciary Committee and other committee hearings will continue during that time. So keeping an eye on those 3 senators, and if there are any others that may test positive. A couple of those senators were at the Rose Garden ceremony where Amy Coney Barrett was nominated. We're still in the 14-day window of when symptoms could arise and a positive test could arise, so that's still an active situation. The other way that COVID is impacting this hearing is usually the nominees having in-person meetings right now. Justice Sonia Sotomayor notably met with 89 senators with a broken ankle. She walked all over Capitol Hill so that she could meet with everyone in person before her hearing. That's obviously not happening. The nominee met with a few senators in person. We also were wondering if she was going to meet with any Democratic senators, which is typically what happens. She yesterday, in fact, met with 6 Democratic senators telephonically. So some of that's happening, but definitely not in scope with how it usually happens. And then finally, the big change is going to be the hearing itself. Usually the hearing takes place in a big room in the Hart Senate Office Building. I covered Justice Kagan's confirmation in person. I've been in the room. It's swarming with people and photographers. That's not going to be what happens here. Chairman Graham has said that senators can join remotely, and we've seen senators join remotely for these types of hearings in recent days. For Justin Walker's confirmation to the DC Circuit, both Democratic and Republican senators participated remotely. So we'll see what happens, but they are going to split the dais so that senators will have more separation from each other in the room. The nominee, I understand, will be physically present in the room along with her family and a few members of the administration. But that's about it. The public will not be allowed in. It's typically allowed in and allowed to watch these historic moments of confirmation hearings. And also the press will be severely limited. There's only going to be 10 seats reserved for members of the press. Whereas if you compare that to the most recent nomination, Justice Kavanaugh's confirmation hearing on day 1, there were over 107 credentialed press. So all of the information coming out of the room we'll be able to see live, but will also be filtered through only about 10 press members that are actually physically present in the room. So all of these things are happening and kind of molding how this nomination and confirmation battle is going to be different. And hopefully that sets the stage for then Steve and HW to talk about all the differences that we'll see with a potential Amy Coney Barrett on the bench.
Great, thank you, Katie. That was really great. It's a little bit nerve-wracking to follow you. But I'll just say, so one sort of more procedural, I think, addition that I think might inform some of the story as well is, I think that my read of this, and I'm curious, Katie, if you disagree, is that one of the reasons why the majority leader is in a big old hurry to get this done is because even if he has a quorum, I'm not sure he's convinced he has a majority on the far side of the election if the Republicans lose both the White House and the Senate. right? And that there's at least the specter to him that one or two of his colleagues might soften, not on the merits of Judge Barrett, but on the timing of it. If this isn't wrapped up by the time it's clear who wins the election. And of course, there's the additional procedural point that at least the Arizona election is a special election. If Senator Kelly defeats McSally, he'd be seated, I think, November 30th, right? And not January 3rd. So, I think the timing is part of the story. And it's also part of, I think, the Democrats' frustration, which is that there's, I think, the very real sense that McConnell's doing it now, notwithstanding these health concerns, because he's not sure he's going to be able to do it anytime later. I don't know if you disagree. Before I pivot to doctrine, I'd love to hear your thoughts.
No, I think that's definitely right. And in addition to Arizona, Georgia is actually also a special election. Arizona is a special election to finish out Senator John McCain's seat. Georgia is to finish out Senator Johnny Isakson. So Georgia's elected senator could also be seated as early as November 30th when those elections.
Although that would require the Georgia race to not go to a runoff, right?
Yes, which right now it is. So we'll see.
So all this is to say that, like, I think one of the things that makes this confirmation unlike one we've seen in a while is that there is a procedural objection in the speed where the election is doing a lot of work in cabining the time period. And so part of what's making the COVID piece of this such a big part of the story is that for whatever reason, Senator McConnell doesn't believe he has the wiggle room timing wise that he might have otherwise had. Right. That, I mean, you said, I think, we were 26 days before Election Day. I was reminded in the vice presidential debate last night that when Chief Justice Taney died in 1864, it was 27 days before the election. And of course, people are already voting. So I say this not as not to sort of color, right, the discussion, but to say that there's context here that makes all of this completely insane, right, from a political perspective. All right, I'm going to turn away from the politics for a second and actually talk a bit of law and specifically doctrine, and assuming that the quorum issues are surmounted and the vote is in, and Judge Barrett becomes Justice Barrett sometime between now and Election Day. What's that going to mean for the court? And what I'd like to do is sort of put out a bunch of things. I think folks who know me will know that whether I think these are features or bugs. And we might disagree about which one it is, but I think the descriptive part is these are ways the court is going to move. And we might just disagree about whether that's a good thing or not. So in a world with a Justice Barrett, we would have a solid 6-3 conservative majority, the likes of which I don't think we have ever seen on the Supreme Court. I mean, there's a lot of references to the New Deal era. And the critical thing about the New Deal era, where you had a court that was very hostile to FDR, is that one, some of the hostility was unanimous. So Humphrey's executor, the sort of perhaps the apex, right, of the 1935 revolution against FDR was 9-0. But two, the way that you had a 6-3 split in the other cases, you had the four horsemen, right, joined by the more moderate Chief Justice Hughes and Justice Owen Roberts, right? Whereas today, like, I don't think there is a Hughes, and pun aside, I don't think there's a Roberts, right? That, like, the current Chief Justice Roberts and Justice Kavanaugh are not the second coming of Hughes and Owen Roberts. What do I mean by that, right? So what I mean by that is that I think we will continue to see a small number of cases like we've seen over the last 2 or 3 terms, where there are sort of 1 or 2 sort of cases a term where the progressive justices are able to pick up 2 of the conservatives. And so, the big one that stands out to me from last term is the Title VII case, Bostock, where you had both Justice Gorsuch and the Chief Justice joining the 4 more progressive justices. But the reality is that's going to be the exception, not the rule. And even if the Chief Justice is inclined to join with the lefties a bit more than he might have been previously, that won't change the result. The question is, where is the 5th vote coming from now? And I don't think it's going to be a Justice Barrett. And what that means is that I think there will now be a solid majority for any number of conservative moves across doctrines. I don't think that means the end of Roe, but it certainly means ever more abilities for states to restrict access to abortions. It almost certainly means the end of whole woman's health. And so whatever is left of it after the chief's concurring opinion from June Medical. I think this means almost certainly the end of Employment Division versus Smith, and that the court, which it'll have a chance this November, that for all the attention on the ACA case, I actually think the most important case the court's hearing in November is Fulton versus City of Philadelphia, where one of the questions is, should the court overrule Employment Division versus Smith? Justice Barrett would be on the court in time for that. And of course, overruling Employment Division versus Smith opens the door to a universe of new challenges to local, state, and federal regulations that burden religious practice, even if they're neutral. I think it means a fairly dramatic shift when it comes to how the court approaches criminal procedure, criminal justice issues. So we've seen in the last couple of years, Justice Gorsuch sometimes crossing over to join the lefties in libertarian contexts, where sometimes we also saw Justice Scalia join the lefties. I don't expect that from a Justice Barrett. And in those contexts, right, even if Gorsuch crosses over, it's still 5-4. I think we also are going to see now, for sure, the court taking up more Second Amendment cases and putting real teeth, putting some teeth into the right that the court recognized in Heller and McDonald and then didn't say much about. Just to throw one out there, then there's a Ninth Circuit panel last month that struck down California's ban on large capacity magazines as violating the Second Amendment. Without getting into whether a magazine is protected by the Second Amendment, let me just say, that strikes me as candy to the new majority, right? And on separation of powers issues, I mean, to whatever extent there was some constraint on the sort of immediate current court's willingness to really push back against Morrison versus Olson and cases recognizing Congress's power to carve out some modicum of independence in the executive branch, I suspect this is the end of that. The last piece of this, next, I've been talking too much, I want to throw it open to HW, is I also think that a Justice Barrett in a Biden administration, if we get to that point, is going to be perfectly content with striking down and joining the other conservatives to strike down any number of aggressive policy initiatives we might see coming out of the Biden administration. That I think the court has left itself plenty of wiggle room to be very skeptical of aggressive moves on climate change, Medicare for all, if it actually gets anywhere in Congress, almost anything that the administration tries to do through regulation. I don't think Justice Barrett is going to stop the freight train that is the revival of the non-delegation doctrine. And so, I think we are in for, until the next unpredictable cataclysmic event that shifts the function, that shifts the sort of the focus of the court, I think we are in for a conservative hegemony, the likes of which we haven't seen, certainly in all of our lifetimes, and I'm not sure we've seen it at all in the history of the court. And then the last question, and this might be a good place to segue to HW, is how does Congress respond to such a move, right? That is to say, one of the story we tell in our con law classes is, we hold out FDR's court packing plan as a failure. But of course, part of why it failed was because it became unnecessary because the court moved. But what about Jefferson's court destruction plan, right, which actually largely succeeded? What kinds of moves, if we see a entrenched conservative majority on the Supreme Court, and if we see, a multiple cycle period of one-party Democratic rule in Congress and the White House, what does that political process then look like? Do we start to hear serious conversations, not just in the media, but actually in Congress, about expanding the size of the court, about limiting the court's jurisdiction, about other moves Congress could pursue constitutionally that it has historically avoided for normative reasons to protect the legitimacy and independence of the court? And, to me, as I think about what a court with a Justice Barrett looks like, that is the most interesting, most important, and most difficult to predict question, which is, will the court in any way be intimidated by or concerned about overreaching in a scenario where the rest of the American political sphere is controlled by the Democratic Party? HW, you can start there. I think you're muted.
Thanks. And it's knowing some of the names that are sitting out there in the audience, it's all I can do to not just start calling on some names, but I'll resist that for the moment. What I was saying is you stole a little bit of my thunder, but I do think you point to a really fundamentally interesting question that political science has spent a fair amount of time investigating. So I'm going to be a little bit political science, social science wonky today. That's my role to play. And what do we know from political science, and what do political scientists say about the nature of the Supreme Court? But then advance it to a little bit of how some of that relates to the current, not appointment of the justice so much, but the role of the Supreme Court in the election in and of itself. So let me begin by saying that there are some, political science has spent a lot of time, at least in part of its empirical work, thinking about questions like the Supreme Court's legitimacy. And there are basically two directions that the research has gone in the last several years. One is about the Supreme Court's legitimacy as an institution. And the other is research about the extent to which certain decisions or certain outcomes of the Supreme Court shape public approval of the Supreme Court. So I'm going to talk a little bit about that and then maybe move to the current election. The legitimacy question is one that there's been a lot of research that over time, the US Supreme Court has been extraordinarily resilient to claims against its legitimacy, at least certainly in a post-New Deal era. And that for all of the arguing about, is this going to bring about all kinds of changes on the Supreme Court, as an institution, it has remained very strong in its sense of legitimacy among the American people. And no serious threats to the role that it is seen to be playing. But I think that's an important question now because of what you were raising, Steve, and that is, at some point, will these other political pressures that I'll say a little bit about, will they react to that in a particular way? But where most research is going these days is on what is the effect of Supreme Court opinions on public attitudes of approval. So legitimacy is a bigger question, the legitimacy of the institution to do the functions that it does versus the public's current level of approval of the Supreme Court, as we might say about other types of institutions, the Congress or president. There have been a variety of theories. I'm just going to focus on three of them. There's some evidence, or some people who argue in political science, that that public approval for the Supreme Court is shaped by attitudes of doctrine and or a certain approach. Like, is it originalist? Is it legislating from the bench and these types of things? So there's some research that talks about that line of thinking. There's a second line that goes along that says people want judges to assume a certain role or function in society. And as long as they maintain that function or role, people will have higher ratings of approval of the Supreme Court. I should note, and should have noted, that the Supreme Court has much higher approval ratings, regardless of which way it's going, than other institutions over time. And so an example of this is separation of powers. If they're seen as continuing to play an adequate role of protecting separation of power, if they're seen as having judicial independence and so forth and so on, that keeps their approval levels high. And then there's a third line of this approval research, again, not legitimacy research, but approval research is increasingly focused on how particular decisions of the Supreme Court drive approval ratings and how robust they are and how long they last. And as with any kind of social science research, there are all kinds of empirical studies and different data things that, are finding support for one over the other. But one of the things that we have been increasingly, what we do find, and what is kind of intuitive, is that, of course, if the Supreme Court makes certain types of decisions that people think they disagree with, we will see temporary drops in their approval rating, particularly among people that feel the decision went the wrong way. And way more than you want to know for this kind of context, but there's a lot of debate about how that's driven. Is it driven by identification with particular parties, the notion of approving president's appointment of certain types of justices? Is it driven by that understanding that they identify with it's their court or their president's court? Or are they reacting to their interpretations of decisions itself? The most dramatic example, of course, might be Roe versus Wade and abortion opinions, but even that can often be tempered a lot about some idea of whether or not the court has acted in particularly proper ways, though it does rise and fall. So let me talk a little bit about the approval in the current court. And now I'm just going to I'll be looking at things because I'm looking at some recent polling on this, particularly by Pew, a little bit by Gallup, but mostly by Pew. People talk about the Supreme Court as being very important in their decision, but a lot of exit polls begin to belie how important it actually was. That they'll say it's important overwhelmingly in exit polling, and to the extent that we can do this in sophisticated ways, that didn't seem to be the primary driver of a vote. Now, there are some exceptions about that. Among people, for example, in the 2016 election who saw the court as being their most important or one of their most important decisions, that did seem to drive a lot of that particular portion of the Trump vote to, in fact, cast their ballot based on that, irrespective of some of their other decisions. But that wasn't the largest group of Trump supporters, where the economy and actually terrorism and some other things were more important. And so we have to be kind of skeptical about how we think in terms of how important people say the Supreme Court appointment is to them. In the last several years, it has played a much bigger level for Republicans than it has for Democrats in terms of where they rank the importance of the Supreme Court in its determinant, how it will determine their vote. But some polling last week was really came out that distinguished the 2016 election from the 2020 election, and the polling is from Pew, but some other reputable polling organizations find the same thing. For the top voting issues in the 2016 election, issues, and this is all voters, was economy, terrorism, foreign policy, healthcare, gun policy, immigration, social security, education, and then Supreme Court appointments. So even though it was seen as a very important list, it was way down the list of what voters, how they prioritized, or how many saw, that wasn't quite correct, how many of them saw it as a very important issue. For the 2020 election, it has actually jumped to number 3, whereas now 79% will list the economy as very important, 68% healthcare, and very surprisingly, in a way, Supreme Court appointments has become the third most popular, 64% listed as a very important issue. It remains to be seen if that really shapes the vote in any particular way, but it is a change, and an interesting change that's a little bit more dramatic about this is that now Democrats actually outweigh Republicans in the terms of how they see that, although they're still very close. So just as an example, when it comes to healthcare, 84% of Biden supporters say it's one of the most important issues, but only 48% of Trump supporters. But Democrats and Republicans, in terms of their approval of the Supreme Court, are very, very close, and they both see it, but with a slight bump to Democrats in this particular time. Now, all that said, when people vote, it's a complex activity on lots of things, but there are single issue voters out there. That's often been the case for people's belief in abortion, but generally that doesn't explain a lot of the vote. But it is a significant number that in a close election, it might explain it. So that's kind of from the wonky stuff of political science to the current election. But another interesting question is one where I'll stop with when I think Steve was raising the important ideas about, and that is the perception of the legitimacy of the court as serious arguments come to the fore about court packing, and increasingly views of people seeing perhaps a more polarized Supreme Court. It may begin to be evaluated more like Congress and the presidency. The final thing I'll say is that there's a lot of political science on another issue that you raised, Steve, and that is the extent to which the court feels constrained by Congress. There's a long history of research on this. It's controversial, but many people suggesting that the court, particularly in statutory interpretation, does feel constrained by the court in ways even beyond not court packing so much, but things about revising rules of standing or other types of issues of jurisdiction. And whether we believe it or not, there's sufficient research that seems to suggest that the court is attuned to those things, particularly in some of your bailiwick issues, and also in things as it relates to things like administrative law and so forth. So that's the kind of political science stuff to add to this. And that's it for me.
I think we have one of the first questions that came in kind of hits on this legitimacy issue that we've ended on pretty hard. And I'll just open this to whoever wants to answer. We can kind of, unless a question is specifically directed at one of you, I think that you'll all have good perspective for these. So the question is, do you think we could reach the point where some programs are so highly demanded that even if the court said that the program was unconstitutional, it would be implemented anyway? As in, the court was just ignored, relied on the executive to enforce the decision, and they just didn't do it.
I mean, I think this goes to sort of why I think the court packing discussion is not happening with enough nuance, right? That I think there's no chance, even if Biden wins and the Democrats hold the House and end up with like 53, 54 seats in the Senate, there's no chance that court packing happens in January, right? That the better question is, if we get 3 or 4 years of the Supreme Court striking down, policy after policy after policy, including in cases where they're doing so on dubious grounds, that's where the momentum would come from. So to Elizabeth's question, I think the short answer is not right away. But yes, I mean, when HW talks about the court being sort of wary of Congress, right? Like, Congress has a whole bunch of both conventional and nuclear weapons in its arsenal when it comes to the Supreme Court. And the court has historically done a remarkably careful job of not provoking Congress into firing them. And I don't think that the mere fact that a Justice Barrett is confirmed in these circumstances, fraught though they are, is going to impel Congress to take the safety off, right? But the next couple of years are going to be really important. So, to the non-delegation point, right? I mean, if we see a court that next term, parties like it's 1935, and goes all in on reinvigorating the non-delegation doctrine to the point where they're striking down all kinds of federal statutes, I think that's where you start thinking about the legitimacy conversation, right? And what's going to happen, for example, in the 2022 midterms, right? In a world in which the first 2 years of the Biden administration have been popular Democratic policies thwarted by a conservative Supreme Court. So, that's where I think this really is a multi-stage conversation where nothing's going to happen overnight, but where there's the specter of iterative erosion of legitimacy.
I think that it will take an enormous amount of political will if, to Steve's point, they had the presidency, even 54 senators, and took the and had the House to pack the court. And that would mean sacrificing a number of policy initiatives that Democrats in particular pride themselves on putting first. Things like healthcare and climate change and all of that would have to move to the bottom. It can certainly be built politically as the Supreme Court is the first priority for those things to get through. But I think it would take an enormous amount of political will. And I have a hunch that they might not have that political will in the beginning, at least. But I actually wanted to ask HW. I found those statistics and the research about voters thinking that the Supreme Court is more important, and in particular comparing it to the 2016 election, and then generally not thinking the court's important. And perhaps asking you to extrapolate just a bit with this 3-week timeline that we're on right now. Do you think that voters are savvy enough to know or to understand that, if Barrett were confirmed before Election Day, in that week before Election Day, that they would then shift all of their thinking toward, okay, well, the response is the Supreme Court is really important, so we need to elect people that will pack the court, or the Supreme Court is really important, so just in case we need to appoint a president that may get a shot at appointing someone. I guess my question is, how do you think her confirmation happening on the eve of the election would factor into what and how they think is important about the court? Or do you think that's a long game that we'll really start to see the results of, to Steve's point, in 2022?
Well, it's a great question, and all I can do is guess. But here's the way I'll try and not really answer your question, but give you some thoughts about that. I agree with everything you said about it being long-term, in the same way with Steve. It raises a lot of money from donors and, mobilizes stuff like that. Most of the American people, I don't think, are really thinking a lot about the Supreme Court packing. But what can change it is a very controversial decision over a little bit of time. So I think the other thing that you hear about this is, in a sense, and I think Steve's right about this, the fight's over in terms of where this court's going to be. It's going there. Unless something happens with the nomination, which seems highly unlikely. But there is some awareness that Justice Breyer is old, and that 6 could turn into a lot more numbers. So I think that could be a motivating factor of, for the Democrats, we've got to, stop the dam, or put up a dam so it doesn't get any worse from their perspective. But what I would, and here's my guess, that most people are not single issue voters. And what this probably feeds into is attitudes about President Trump, which drives, as we know, a lot of the electorate these days, one way or the other, and attitudes about that this is just yet another reason to love him or dislike him. And so I think it probably adds a little juice to the feelings along those ways, but those seem to be so baked in right now that it's hard to see it doing much more. I will say that people know very little about the Supreme Court in just knowledge levels. The number of people who can name the Chief Justice is quite low. The number of people, interestingly, who believe that it is dominated by conservatives or liberals or Democrats, Republicans, the general knowledge of the electorate is low. In fact, they oftentimes key on that if they're coming down with certain decisions that they like, they think their party still has control of the court, whether it's true or not. Now, one of the things we know from social science, the types of polls are identifying like the name of somebody and so forth, that doesn't explain all that much. But to your point, I think might have a diffuse impact and really among people who have probably already made up their minds of how they're going to vote. So I don't know if that's responsive to what you were asking me, or if I went off down a different alley.
Can I jump in for a second and just say, I mean, I also think, I mean, the media, further to HW's point about public lack of understanding of the Supreme Court, right? The media pitches the sort of options available to the Democrats as court packing or unilateral disarmament. And there is a universe of stuff in between those two things. I mean, the notion that a Democratic Congress with a Democratic president couldn't pursue a host of other reforms that would be perfectly constitutional, that would not be nearly as norm destructive as changing the size of the court for partisan reasons. But that would be both a warning shot at the court and in practical terms, change the nature of the court's job. I mean, let's just talk about the court's docket, right? So not so long ago, right, the court was hearing 150 cases a term. And it was really only after the 1988 reforms that the court got near plenary control of its docket. And we saw the rise of cert as the be-all end-all. And we saw this sort of slow but steady progression downward, where, in the 90s, it was like 95 to 100 cases a term. And in the 2000s, when I was in law school, it was like 85 to 90 cases a term. And now we're down in the 60s. Right. And so, one possibility is that the Democrats come back and say, you know what, Supreme Court, we're going to give you more work to do. Right. We're going to increase the category of we're going to make more cases that you have to hear appeals in. Right. We're going to require you to sit more often. There are lots of things the Democrats could do that I think would not be norm destructive, but that I think would be very much reclaiming Congress's role in the conversation where the Congress has long ceded it. And I just, the real question to me, and I guess I put this to both HW and Katie, is that going to affect how more than one of the conservatives votes? I'm confident that exact concern will lead one of the conservative justices to moderate his voting. His name rhymes with Roberts. Right. I'm not at all confident there's a second. And I think that's, so much of that I think is going to come down to, dare I say, Brett Kavanaugh as the most likely candidate for a second institutionalist vote among the conservative bloc.
I actually wanted to ask this earlier of you, Steve, but to turn that on its head a bit, there are some folks out there that are saying Amy Coney Barrett on the bench would actually encourage or give Roberts more breathing room to come back into the conservative fold more consistently and more reliably. What are your thoughts on that?
I don't dispute for a second, Katie, that the chief will vote differently when he's not the median. Right. And so, there will be cases where I think the chief voted with the lefties because he was the median, where he might not now. But on the flip side, I also think the chief might, I have so much intellectual respect for the chief. He is so smart and he is so careful, even if he and I don't agree about almost anything. And I just think that he would understand as much as any of the six conservatives that it is in their long-term interests to preserve the institutional legitimacy and authority of the court. And so, Katie, I can imagine a world where we see the chief maybe not dissenting, but concurring in the judgment a lot more. Right? I think June Medical, was either the second or the first time in his tenure on the Supreme Court where he wrote an opinion concurring in the judgment. That's unheard of, right? For someone who's been on the court that long. I expect to see more of those, where he at least sounds notes of caution and says the right things about institutionalism, even if the ultimate result is the same. I think the real question is whether there are going to be cases where behind the scenes there are conversations about alignments that sort of preserve that sort of dull the sharpness of democratic attacks on the court. And then the question I think is, and who's the most likely partner for the chief in that enterprise? I'm out on a limb here, but I think the most likely partner, only because all the others aren't likely, is Kavanaugh.
Yeah, I don't agree. First of all, let me step back to something you said just before that. And that is, I agree completely with your idea that there is this entire arsenal that they can use. I think where I would part company, it won't be in caseload. The Supreme Court seems always able to control that, no matter what the Congress says that they have to take cases or don't. I mean, I think that ship's already sailed probably, but we could be, we could see about that. But I think it's exactly true in a million other areas of where they could do that. And I actually see, I think it might also, I guess the question that I would raise is or would like to ask is, if we're focusing only on big constitutional issues like getting rid of employment division versus Smith, which is important to note for our students who wrote that. He came to dislike it a lot, but it was Justice Scalia who wrote it.
I remember that guy.
Yeah. So my question is I have one set of thoughts for some of the major constitutional issues that have been really driving conservative viewpoint as it goes along. But it's also been happening in administrative law and statutory interpretation and all of these areas. And that's the one that I'm less sure. I mean, I, like you, have a hard time finding where that other vote comes from on those big issues. I shouldn't say on the constitutional big issues. I'm wondering if some of the arguments that might be playing out in the statutory world, there's opportunities for more movement or administrative.
I guess it's a great point, and I guess the reason why I sort of completely avoided statutory doctrinal pathways in my remarks is because in a world with democratic control of the political branches, I feel like the Democrats can take care of that, right? Which is to say, one of the things when we're talking about sort of moves short of expanding the size of the court, right? I mean, getting rid of the filibuster for ordinary regulation, I think is somewhere in between. And if the Democrats do that, as I think they very well may next year, then all of a sudden that opens the door to the Democrats, answering a lot of these questions just by statute. And I think the court would be resistant to some of it, but they couldn't be resistant to all of it because we're all textualists now. And so if Congress is speaking clearly on a matter in which they're allowed to speak clearly, where there's no constitutional question, I think the question will be, does the court try to find new mechanisms for pushing back against those kinds of statutes? And again, that's where I think the elephant in the room is non-delegation, right? Not some kind of new set of statutory interpretation principles.
It's interesting, although surely you don't believe that despite what we've said, what one person has said a lot in their opinions over time, what they believe in, all of a sudden Jack Balkin can become an originalist. So I'm assuming that textualists can find ways to get to that. I wanted to ask both of you, and Seth or whoever, we don't mean to dominate this. So I know there might be students, but needless to say, I'm always interested in agenda setting. And I think this is clearly a short-term issue for a while, but as you've both pointed out in one way or another, that plays a crucial role of how we're doing things. And I do think it slows stuff down because as most people in the audience probably know, it only takes 4 votes to get cert granted, but it takes 5 to win. And so the court often early in its, when they don't know how that 5th vote is going to go on different types of things, there's a lot more defensive denials that go on in these types of issues that I think will further the point that maybe not a lot is going to happen very fast, but that doesn't mean it won't eventually happen. But I'm wondering if I'm wrong about that. I mean, I can see a sense of the court wanting to act quickly for lots of different reasons. You can be young and die. So Well, I take the idea that it, and was supporting the idea that it would be slow. I think we could be wrong about that. They may want to really strike quickly about taking up cases to try and establish a beachhead for all kinds of different purposes. And I just don't know.
I will defer to Steve largely because he has a greater understanding of the issues that can come up and the jurisprudence. But to pick up on his calling the Ninth Circuit opinion on magazines candy for the court, and how quickly those of us with a sweet tooth or children can grab for candy, I think that might be an area where they do move quickly. And to your point, where there are definitely 4 justices that would grant some of those cases, common knowledge is that they've been holding back on that, not knowing where the chief may be. And Amy Coney Barrett is most likely to be in their camp on, clarifying and expanding what the Second Amendment protects. We only have one dissent from her on the Second Amendment, but it's pretty clear about following history and tradition, similar to what we saw from Justice Kavanaugh, who also had a dissent before he was confirmed with a similar language. So I think that might be one area where they move quickly, but I defer to Steve on his wealth of knowledge on the subject.
No, I think that's right. And I think the other thing is that I think the Second Amendment's low-hanging fruit because there's no precedent that they have to overturn to do it. Right. That if legitimacy is going to be a motivating factor in how at least 2 of the conservatives are voting in the cert pool, and really even 3 of them, the Second Amendment's not an area where that's a big deal because that ground is open. Right. Whereas, if we start seeing states trying to make incursions into Obergefell, I think that's a different kettle of fish. And this, again, this goes to the long-term piece, but I think it's also worth stressing that, the long-term can become the short-term pretty quickly. And what I mean by that is, it's not just that Justice Breyer is no spring chicken, it's that Justice Thomas is no spring chicken. Right, relatively speaking, sure, but like if we have, a 2-term Biden administration, by the end of it, at least 2 of the 6 conservatives are going to be well into their Medicare benefits. And so, I think the other piece of this is that, we do this thing where we spend all this time talking about what's the next 20 years of the court going to look like. And then in year 3, something seismic happens. And so I think, this is part of this is that the court is both a sort of political, a low politics and a high politics institution. And I think it's going to be, low politics for a little while, but with high politics in the background. And I think that's with an eye toward what Congress could do. And so, for example, I think this might sound crazy. I think some of the decisions we get out of the court in the next couple of years might depend upon whether the Democrats have 51 seats in the Senate versus 54. That seems crazy, but I think that's just the way it is.
I would also add one point to that I've kind of gleaned from talking to some conservatives and political actors that have thoughts on this, and that how quickly the court moves and what it moves on will also maybe depend on what's politically beneficial in 2022 and 2024. And in particular, to Steve's point, Justice Kavanaugh might be the swing vote to the extent that the other ones definitely won't be. Kavanaugh is also a highly trained political actor and will keep in mind certain topics that are politically beneficial to run on in 2022 and 2024. And so, to the extent that they're granting certain cases, that may or may not be a consideration in certain things that Republicans traditionally and reliably run on to their benefit time after time. And I think Roe is included in that.
I completely agree. I do have to step off in a minute, and I'm sorry to have to. You guys should keep going. I just got to go. But I do want to say there are a couple of questions in the queue about like longer term, like term limits and or longer term expansion of the court. And I just think that those are all like, thinly veiled efforts to end up in the same place. Like, I don't think term limits solve the problem of the courts and the unpredictability of actuarial tables and the partisan political, the partisanization of the confirmation process. Expanding the court, like, so that there's 15 judges in 15 years. I still think, raises, I mean, I don't think the court is overworked, which is usually the justification for expansion. I do think though, and this is, part of the pitch here is you should take federal courts, although not with me. I do think that we spend not enough time, especially as the folks most likely to know this stuff, right? Talking about the far more nuanced, interesting, sophisticated, below the radar ways that Congress and the courts are in a conversation with each other on everything from budget to security to jurisdiction to docket to there's a universe of issues out there. And Congress has in the last 25, 30 years largely abandoned the field. I think it's clear now that's going to change. And I think the question is just, how where does our comfort level leave off with that? And I think the court's going to have a lot to say about that because it really is a dialogue.
Thank you, Professor Vladeck. Oh, do you mind?
Go ahead.
I was going to say thank you for coming. If you need to hop off, Professor Vladeck, I totally understand. I will, in the spirit of pitches, say that we have events on both Bostock and on Fulton, which were both mentioned today, coming up. And I'd imagine that, especially on the Fulton event, this topic about Amy Coney Barrett will come back up again. But if you don't mind, Professor Perry, there's actually a question directed at you.
Yeah, I'm sorry, I never read chat while I'm doing things. And when Steve said, well, I see the questions coming up. And I just glanced for a second. I'll let you do them because I wasn't ignoring them. I just didn't know they were out there. So
no, it's okay. And I think, we've had a fantastic conversation. If people need to head off to class, I totally understand.
Yeah, I have to teach my Common Law 1 class pretty soon. And if any of them are sitting out there, they know they've got a lot coming today. But go ahead. I was
just going to, Henry Humphreys asked, how are political scientists viewing the shift from near unanimous consent in confirmation of Supreme Court justices to generally party line votes that we're now seeing?
Well, not only political scientists, but the whole world since the time of Robert Bork has changed its thought about that. They weren't, that was a watershed moment. And with Bork, and since that time, I think there's not an expectation that it won't be driven a lot by partisanship. That I think in some ways the area where that's though playing out more problematically, and I'm not, and maybe there's some chance for it to become less politically driven, is the problem with appointing lower court judges. I mean, the number of vacancies on federal court benches and other places has risen to huge problems of just bringing up hearings and those types of things. So maybe there may be some reaction to say, we got to stop that. I don't predict it, but I can see reasons yet. For Supreme Court nominees for a long time, I think people, whatever they think, I think political scientists just observe the behavior there and think with Bork, yeah, I mean, there's some exceptions since that time, but it shifted what was allowable in those types of debates. What's also interesting, though, that political scientists talk a lot about and having to deal with their data as they analyze these types of things, is there was a time that there was an overwhelming number of unanimous opinions on the Supreme Court, and the play and the action were in the relatively small numbers that were not unanimous. And now, of course, the number of unanimous opinions has dropped precipitously over the years. And so I think that might even be, Mr. Humphrey's question, I think, applies to that as well, as what's happened to the unanimity in areas where it might not have been seen as needed to be so, not hammering out a unanimous opinion.
Cool. Well, I think, we had a lot of great questions that we weren't able to get to. I apologize for those that asked, but this has been a great discussion. Katie, thank you so much for joining us. We appreciate it.
Thanks for having me.
Did you have any last thoughts, or are we all good?
I'm good.
Cool. All right. Well, Professor Perry, please, if you haven't already moved on from Marbury versus Madison, today's probably the day.
Now, we finally got off that in McCulloch, but believe it or not, we're all the way to Wickard versus Filburn, because this class is so much smarter than your class was, Mr. Smitherman. I could go faster. That's, so we're further along. Thanks for inviting me. So
I
And Mr.
appreciate it.
Baird too, so Tanner and Seth.
But thank
Thanks,
y'all so much.
everybody.
Our next event will be Monday, and we very much appreciate y'all's time.